Generally, in corporate mergers and acquisitions, corporate management and majority shareholders owe minority shareholders a duty of entire fairness in the transaction. Consequently, in an action to determine whether a proposed merger between a parent corporation and a subsidiary, which the parent controls and which has minority shareholders, should be enjoined, courts review the merger under an entire fairness standard of review. In the 2001 case Glassman v. Unocal Exploration Corporation, the Delaware Supreme Court considered whether, in a short-form merger, that is, a merger between a parent and subsidiary that doesn't require shareholder approval, the parent has to establish entire fairness of the transaction. Unocal Corporation, which we'll call Unocal, is a Delaware corporation that's engaged in the exploration and production of oil and natural gas. In addition, Unocal Exploration Corporation, which we'll call Unocal Exploration, is a subsidiary company of Unocal that's engaged in the exploration and production of oil and natural gas in and around the Gulf of Mexico. Further, Unocal owns approximately 96% of Unocal Exploration's stock. In December of 1991, Unocal and Unocal Exploration's boards appointed special committees to determine whether the corporations should merge. Unocal Exploration's committee consisted of 3 directors who were also Unocal directors, but not Unocal officers or employees. Unocal Exploration's committee also retained financial and legal advisors for the proposed merger. In February of 1992, Unocal and Unocal Exploration announced they would merge. Under the terms of the merger, Unocal Exploration shareholders were to receive slightly more than 1/2 of a share of Unocal stock for each share of Unocal Exploration stock they owned. The notice of merger and prospectus also advised Unocal Exploration shareholders of their appraisal rights, or their right to receive fair value for their shares after evaluation by the court. At the time, Delaware's statute on short-form mergers provided that, if a parent company owned at least 90% of a subsidiary company, the parent may merge the subsidiary into itself by filing a certificate of merger and ownership. Subsequently, a group of Unocal Exploration's minority shareholders, including Morris Glassman and William Steiner, sued Unocal and its directors in Chancery Court for breach of fiduciary duties of entire fairness and full disclosure. Following trial, the court found for Unocal and held that the prospectus didn't contain any material misstatements or omissions, the entire fairness standard doesn't apply in a short-form merger, and the plaintiff's exclusive remedy was the right of appraisal. Glassman, Steiner, and others appealed to the Delaware Supreme Court.